Okay, this video is going to address the rights that people have but aren't specifically mentioned in the Constitution. And this is a major point of dispute right now involving a really kind of critical issue. Okay, so we've talked about the rights that, even can be controversial when they're written down in the Constitution. But do people have rights that are not specifically mentioned in the document, right? So this kind of goes back to something we talked about maybe a little bit in the judicial branch unit when we talked about like activism and restraint, right? Those people that support activism might tend to say, yes, people definitely have rights that are not specifically mentioned in the Constitution. Those that adhere more to a judicial restraint philosophy might answer this question by saying no. Remember, activists today tend to be more on the liberal side, and those supporting restraint tend to be more on the conservative side. So this is going to set the battle between Democrats and Republicans on a whole bunch of issues that aren't specifically addressed in the Constitution. Okay, so historically, the term penumbra basically refers to a shadowy region produced by like an eclipse. So it's a scientific term that's kind of been stolen into like the legal world, right? So again, this is like a shadowy area. It's like the gray area produced by like a solar eclipse. In 1965, Justice William O. Douglas first used this term penumbra to deal with like the unstated right to privacy. He looked at this as like a gray area, a shadowy area in the Constitution, specifically dealing with the unstated right to privacy. So this is like Douglas's argument. Douglas's argument is that nowhere in the Constitution does it say that people have a right to privacy. So if you literally interpret the Constitution word for word, you're going to come away thinking that there's no right to privacy in the Constitution. But Douglas argued that if you look through like the amendments, you kind of get a vibe of privacy. So the First Amendment gives you privacy over things like your speech, your political views, your religious views. The Third Amendment gives you protection over your home. You can't be forced to quarter soldiers, to house soldiers, to feed soldiers against your will. The Fourth Amendment gives you sort of like privacy over yourself for being illegally searched, and your stuff from being illegally searched, your property from like law enforcement. So Douglas basically said, like, okay, the founding fathers didn't specifically say you have a right to privacy, but man, they did protect a lot of things that sort of are related to privacy. So I'm just going to go ahead and think that the founding fathers really cared about privacy. And he used this way of thinking to rule in the 1965 case of Griswold v. Connecticut, which overturned Connecticut's ban on contraception. So Connecticut basically had outlawed any kind of like birth control, any kind of contraception. And Douglas basically argued that this was a private decision involving your own body, right? What, like dealing with birth control. And that he claimed that this right was in the Constitution, although unstated, because of all of the other things that were written down, right? So he believed there is such thing as unstated rights based on stuff that is stated, if that makes sense. So this is important because it leads us to like the epicenter of the major division over a key issue today that separates Democrats and Republicans, which is the abortion debate. So knowing what activists and restraint believe, that activists are more willing to like read between the lines, and restraint people, which tend to be more conservative, tend to be like what is actually written in the Constitution. That shows you how the Supreme Court has ruled two different times on abortion and come out with two very different verdicts. So in 1973, the Supreme Court, which was more liberal than conservative, ruled in Roe v. Wade that women do have the right to an abortion if they choose to pursue it, right? And the thinking behind this is, again, like the Constitution, through the First, Third, and Fourth Amendments, gives off the vibe of privacy. That a woman deciding what she wants to do with her own body is a matter of privacy. Therefore, abortion should be legal. And that was the interpretation of the court. Federally protected abortion rights. Like states could not prevent a woman from getting an abortion after Roe v. Wade until 2022. Between 1973 and 2022, the court has changed to be a majority conservative. So in 2022, in the case of Dobbs v. Jackson, the Supreme Court overturned Roe v. Wade because they said that you can't federally protect something if there's nothing in the Constitution to provide sound guidance on that decision. So, since the Constitution does not actually mention abortion and the protection of it in the Constitution, it can't be federally protected. You can't like read the Constitution and get a vibe. If it's not there, you can't protect the right. So they basically struck down Roe v. Wade. Now, that does not end abortions in the United States. It just basically says the federal government can't force the states. There's nothing in the Constitution that allows them to force the states to allow women to have abortions. So right now, it's a state by state decision, and largely it's a matter of like what political party controls your state. If you are a state that is controlled by Democrats, you're tending to still see abortions be legal. If you're a state that's controlled by Republicans, you're now seeing those states outlaw abortions. So this just shows you a little bit about how unstated rights are looked at differently between the parties and how this has led to two different decisions regarding the abortion issue.